So I've rewritten the Air India and Nargesh Mirza judgment. And the reason I've rewritten it is that it's one of the most significant failures of the Supreme Court in respect of the Article 15, Paragraph 1 and Article 16, Paragraph 2 jurisprudence. Basically, what the court does, it drives a wedge between sex and gender such that only the biological category of sex is protected from discrimination, and its social incidence, basically gender discrimination, is not protected under the Equality Code of the Constitution. And it closes its doors to intersectional discrimination, so discrimination which is based on more than one ground under Article 15 paragraph 1 and 16 paragraph 2. So what I've tried to do is to tackle that reasoning. The context of the case is that the Air India and Indian Airlines air hostesses brought this claim where they were saying that the retirement conditions, which you retire when you reach the age of 35 years, or you marry within 4 years of service, or upon first pregnancy you have to retire. The court in this case comes to various conclusions, but the idea that the court is empowering women by telling them to reproduce and upholding conditions like the pregnancy conditions such that women should be given more time to reproduce, they should marry late, it's important for protection of the institution of marriage. These are the very problematic stereotypes which the court uses in order to come to a holding which is similar to what I come to. So it's a way of both showing that rewritten judgments can actually end up concurring in substance, in its holding, but substantively they're quite different. So it's excavating that feminist reading of Air India and Nargesh Mirza.
And I think this is very interesting because when I was called, to be a discussant in the paper, I hadn't read Nargesh Mirza since college. And, vaguely there was this idea that it's a pretty progressive judgment and it got some things wrong. And then when I read the judgment, I was truly shocked. So I'd just like to read this para. So there were 3 grounds. There was age, marriage, and pregnancy. So the marriage restriction was upheld. And the court says this: apart from improving the health of the employee, it helps a good deal in the promotion and boosting up of our family planning program. Secondly, if a woman marries near about the age of 20 to 23 years, she becomes fully mature, and there is every chance of such marriage proving a success, all things being equal. Thirdly, it has rightly been pointed out to us by the corporation that if the bar of marriage within 4 years of service is removed, then the corporation will either have to incur huge expenditure in recruiting additional air hostesses, either on a temporary or on an ad hoc basis, to replace the working air hostesses if they conceive, and any period short of 4 years would be too little a time for the corporation to phase out such an ambitious plan. I mean, you would hope that in 2018, such language would never be used. And I think what's really interesting from the dissent that Shreya has written is then contextualizing that in today's day and age, and to see whether the Supreme Court has moved forward on ideas of gender justice. While we have judgments like, Sabri Mala and Joseph Shine when it comes to adultery, or Nafte Johar, which, talk about now like patriarchy, the idea of social and stigmatization, institutional discrimination. And you would hope that today, this language of a transformative constitution would be employed to never again write judgments like this. But I think what Nargesh Mirza also tells us, and what Shreya's dissent really tells us, is there's still a long way to go while talking about the difference between equality law and discrimination law, and how intersectionality would really apply. So.